Hey there, this is B. I'm going to do something a little different this time. All right. This time, I want to dig into the motion that Grindr has put before the court saying that my case should be dismissed and forced into arbitration. Well, actually, they have said both of those things, but yeah, it's kind of confusing. Let's get into it. So I'm going up against um, this young lady. Victoria Weatherford. And yeah, so right off the bat, let's look at the title of her motion. Defendants Grindr'S LLC's Notice of Motion and Motion to Compel Arbitration. Nowhere in that title does it say dismiss. Do you see dismiss there? No. But when you search for dismiss in the body of the motion, right underneath, then what does it say? And hereby does bring its notice of motion and motion to compel arbitration and to dismiss. That is it's a pretty small flaw, but it's actually a procedural flaw. It's just sloppy. You're doing so right off the bat, I know that this person is doing sloppy legal work. They don't even pay attention to the titles of their motions. So the the title of the motion should be and to dismiss, but if you don't put that in the title, then you haven't brought proper notice. It's procedurally wrong right off the bat. Okay, so let's go to the next point. Okay, so maybe more of the meat of what they're saying. They say in their language, and let's just bring that up real quick. The next is concerning FAA. Okay. Grindr's motion is made pursuant to the Federal Arbitration Act. Okay. And what does the FAA say? The Federal Arbitration Act, okay, binding precedent, make it clear that the plaintiff cannot shrink her contractual obligations, including her obligation to arbitrate her dispute with Grindr. Okay. But in order to have an arbitration claim, they have to do this. Plaintiff agreed to arbitrate her claims against defendant Grindr. Okay, so when you have an agreement, there should be a contract. And so where in this motion or any declaration have you provided the agreement that we agreed to, the so-called agreement? Where is it, honey? It's not here. They don't provide any proof that I, B. Davis, agreed to their terms of service and this clause that says that I have to arbitrate. Where is it? Instead, this is what they do. They say that Grindr's a mobile app, okay? Users must create an account and accept before there is manifest assent to the terms of conditions. So they go through all of this. They show their screens, their generic screenshots. They don't show my name inside here anywhere. Okay. And because an applicant must click on the accept button to manifest their assent to the terms of service, this type of agreement is known as click wrap agreement. It's not going to work. You need to produce the contract. That's the law. You can't just produce your screenshots. I don't know where these screenshots are from. And guess what? I'm an app developer. I know apps don't always function the way that they're designed. It's possible that this screen was never ever seen. How can you prove? They're showing me screens for an iOS device, but I use an Android phone. So you're saying that you know that your app is flawless and has never had an error or made a mistake, it's never glitched out. How many people have had Grindr glitch out on them? Just put a like, put a comment. Right. So let's review. They have an imaginary agreement that they're trying to use to force me to into arbitration over. And yeah, that doesn't work. That's not the law, honey. Let's go further. So what's the next thing? So the next thing is that their language is that that they're asking the the judge to dismiss my case entirely, permanently, based on arbitration. Okay, that's very, very misleading, and they're trying to invoke Smith versus Sparisi, okay, which is the law that says that that the FAA must be enforced. But here's the thing: there is a Supreme Court decision that just happened like a week ago that basically says that you cannot dismiss a case with forcing it into arbitration. That the most that they could possibly do is force it into arbitration and produce a stay, right? So this, once again, this motion is completely like invalid. It's like dismissal based on Smith and Sparisi. But no, this doesn't. This is not the law anymore, honey. You're a day late and a dollar short, unfortunately. And so this case law is not the law of the land. It was a unanimous decision by the Supreme Court that you cannot dismiss a case when you're trying to force it into arbitration. This motion is dead on arrival. Dead on arrival. Okay, what's next? Okay, the part that they're not seeing and that's not included in this at all is the EFAA. So you have the FAA, you have the EFAA, which says that the ending forced arbitration for people who have gone through sexual harassment, right? Because the nature of the harassment, the nature of the violence that was perpetrated towards me is sexual. Okay, they can't argue that it's not. It is sexual harassment. It is a civil rights violation. Those things cannot be forced into arbitration according to the EFAA. And that was made law in 2022. Okay, so listen, you can pretend that I made a contract with you, but you can't find any proof. You're trying to use an arbitration agreement that doesn't exist based on the theory that someone has to, you know, agree to the terms and conditions based on screenshots that you've presented to the court. Okay, and then you're actually trying to say that the other thing that they missed out is that as part of their arbitration agreement, okay, as part of their clause, they're supposed to actually enter into talks with me in order to figure out how we come to an agreement. Now, guess what? I actually reached out to them via email and with this attorney and said, hey, listen, I'm not trying to get any money out of Grindr. I'm not trying to take down Grindr. What I'm trying to do is get Grindr to come to the table and talk about how we can make the app safer. I will drop the case against Grindr right now if you come to the table with some meaningful protections for the people in my community. And they refused. So this is not about them trying to make anything better. This is all about them trying to silence people who are trying to have their complaints heard. And that's all it is. So there's another part to this, which is the click wrap agreement. And we're going to get into that next time. All right. Bye.